Welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Larry Parker, Chair of the Mergers and Acquisitions Group here at Williams Mullen, to discuss employee benefits and mergers and acquisitions. How are you doing today, Larry?
I'm doing well. How are you, Brydon?
Great. Thank you for joining us for this topic. We could fill a treatise on issues involving mergers and acquisitions and employee benefits. But for this kind of short podcast, what are, in your experience, some of the top issues that you face when you're advising clients who are going through a deal?
Well, it's relatively simple. I think it comes down to what's the form of the transaction and what happens under the default rules under that particular transaction form to the health and welfare plans, the 401k, and what happens under COBRA.
So when you say form of transaction, what are you referring to?
Well, either a merger, an asset sale, a stock sale, and then how that impacts the plans.
Yeah, and to me, as a benefits lawyer, helping you guys when you're going through a deal, it really does matter a lot to me whether it's a stock deal or an asset deal. If it's a stock deal, the buyer is acquiring the legal entity. It's acquiring the company and really stepping into the shoes of that company. So once the deal closes, those two entities are really one legal entity. So the plans, the benefit liabilities, any mistakes that had occurred in plan administration, any outstanding claims, benefit liabilities under pension plans or funding liabilities, those all go with the target that's been acquired. In an asset deal, there's some case law that says there can be some successor employer liability, but really what's happening is the buyer is just buying the business, right? You're buying the assets, the bricks and mortar, the equipment. The employees are terminating employment with their prior employer and then becoming hired by the buyer. And so it's like any other situation where you have an employee who's terminated from the seller's standpoint, or you're hiring an employee. It's just you're doing it en masse. You have a large group of employees coming over. When your clients, let's say you're representing the buyer, what are some issues that you see as far as providing benefits to those employees? What are they thinking when you're acquiring a target company? And what are some of their concerns when they're trying to then run a business after closing?
Well, one of the primary concerns benefits-wise is there's not a gap in coverage. That a lot of times plans will have certain dates where they can pick up new employees, and we don't want to close and have an employee terminated under one plan and not be picked up under another plan. So it's important to plan the transaction around that and make sure that we do have coverage for them.
Right, and sometimes the buyer, depending on what the buyer is, right, you could have a plan, the buyer could have plans that then the acquired employees become participants in those plans. Sometimes the buyer, though, I know you often deal with private equity where the buyer might not have a plan. And so what are they looking for if they don't have benefit plans, but now they're about to acquire a couple hundred employees? What do you see in that context?
Well, it depends on the buyer. Most frequently, they're going to set up their own plans sort of ab initio. But sometimes they want to assume the seller's plans, which means the buyer is going to do an extraordinary amount of diligence to make sure that there haven't been any mistakes like you mentioned earlier on.
Right, and also that kind of goes back to the type of, you talk about diligence, the type of deal. When it's a stock deal, if you are acquiring the entity and if that entity is a plan sponsor, then their plans, unless you have them terminate before closing, are going to go with the company that you're buying. And so your diligence better be pretty strong to know whether there have been any issues or qualification issues. Do you see buyers requiring sellers to terminate plans prior to closing? If the buyer, let's say the buyer has 401k plan and group health plans, they're ready to assume those employees into their plans. What's your view on whether the buyer should ask the seller to terminate its plans?
Usually it's dictated by the plans themselves and what the buyer plans to offer the employees. I have had transactions where plans had to be terminated in connection with the transaction. And you probably have more insight into why that might be than I do.
Yeah, I think in a stock deal, my standard approach is that we want, especially the qualified plans. I'm not as concerned about the health and welfare plans, but the 401k plan, for example, I like those to be terminated just from a risk standpoint, because if you do not have the plans terminate before that target becomes part of the control group of the buyer, then that 401k plan becomes a 401k plan of the buyer after closing. And there are regulations that say that if employees have been participating in a 401k plan within 12 months prior to a termination of a plan, the termination is not a distributable event. You can't get a distribution from the plan because the plan terminates, and that's called the successor plan rule. So if you terminate the plan before closing, before they go into a new controlled group, then distributions can be made from the plan. If you terminate after closing, then they can't get to distribution. So you're really kind of boxed into merging the plans with the buyer's plan. The downside of that, and the reason I don't typically like that just as a lawyer, is that you are then inheriting all the problems that seller's plan may have had. So if they had a qualification error you didn't know about, didn't come up in diligence, which is really possible. I mean, if they had an administrative error, in diligence, we thoroughly go through the plan documents and notices and 5500s and everything we can see if there are problems on paper. But what you don't see is whether there's been an administrative problem. So whether they didn't let people in the plan on time, or whether they were late with their deferrals. Of course, that should be reported through the 5500. Or there's just been some qualification errors that maybe even HR didn't even know about, that they had, right? So if you've merged that plan into yours, it's one plan now, and their problems are your problems. And so that's why I like the plans to be terminated before closing, because you just kind of stop the risk there. But from a business perspective, I've also had clients that want to merge the plans because now they've added more participants, more assets. It gives them more bargaining power. They can get lower fees. So it can have, there are benefits to not terminating and to merging the plan. So it's really a business call. It depends on the facts and circumstances. Clearly, from a legal risk perspective, terminate the plan before closing. But there are, on balance, there could be business reasons, good reasons to want to merge that plan with yours. You mentioned COBRA. I know we've gone around several times in transactions on COBRA issues, and just want to see what thoughts you have on, or some pitfalls, things that a potential buyer might not be aware of with regard to COBRA.
Well, the biggest thing as a buyer I'm worried about is, am I accidentally assuming seller's COBRA obligations for the employees say in an asset transaction where all the employees have technically been terminated, and then I'm hiring them all? Have I inadvertently assumed seller's COBRA obligations, not necessarily for the employees I hire, they're not eligible for COBRA anyway, but for the employees who have recently been terminated or those that I elect not to hire?
Right, and what I think some buyers may not be aware of is that the COBRA obligation can shift to you, and that it's not just employees who aren't hired in the course of the transaction, but it's employees and spouses and dependents who were on COBRA at the time of the sale. So someone could have gone on COBRA 10 months before this transaction took place, and if the liability shifts to you as the buyer under COBRA, you're responsible for providing COBRA to those employees and beneficiaries or former employees. And under the COBRA regs, if the general rule is, and for some reason I always have to reread these regs every time it comes up, but basically if the selling entity ceases to provide any group health plan, and so that's any member of the control group of the seller, then the obligation for COBRA shifts to the buyer. So let's say you have an asset deal and you're buying all the assets and you're getting all of the employees. Well, that health plan is going to go away, and the insurance carrier isn't going to maintain a group health plan where there's only one employee or no employees. And so no matter what you think you're buying, you're going to get the COBRA obligation. The regulations, however, also allow you to state in the purchase agreement who gets the COBRA obligation. So the regulations allow you to override the default rule in the regs. And I think it's something also to watch out for if you're a buyer. When you get that purchase agreement back, whether the other side has put in something about COBRA that would change the result. Let's say they're going to maintain a plan after closing, but they've gotten a little cute and added a provision in the purchase agreement that would shift the COBRA obligation to the buyer, notwithstanding what the regulations provide. So that's something that I think that might not be on the radar of deal lawyers, but it could be a significant liability.
So mechanically, if I'm a buyer and I'm buying all the assets and all the employees in an asset transaction, but I want to have the seller retain the COBRA obligation, how does that actually work if there's no plan left effectively?
Right. So in theory, right, we can shift that obligation, but in reality, in that situation, the seller won't be able to maintain a plan. So really, it's that I think is an adjustment to the purchase price, or there's some sort of reimbursement of COBRA liability, or the cost of COBRA. If the plan's fully insured, then really the cost of COBRA is the potential impact on your claims and your renewal next year, right? Because under COBRA, the employer isn't required to subsidize COBRA. COBRA is paid entirely by the beneficiaries, so it's 102% of the cost of coverage. The entire premium is paid by the employees. So it's not that the buyer with an insured plan is taking on an obligation to pay claims or even pay the insurance rate. That the premiums are paid by the beneficiaries. It's the impact on your claims. But if you have a self-insured plan, now you could really be taking on significant liabilities. If you have COBRA beneficiaries who have really high claims, have health issues that are expensive, now that's hitting your self-funded arrangement, and if you take on the COBRA for those folks, that could be a significant liability that you might miss if you're not really paying attention to it. Is there anything else, Larry, that you think someone would be looking out for when they're approaching a deal as far as benefits?
Those are the things that I'm usually most worried about, Brydon.
All right, well, that's good. And I really appreciate you joining me for the Benefits Companion, and that'll wrap up our discussion of employee benefits issues and mergers and acquisitions. I'd like to thank Larry again for joining me on the Benefits Companion. If you have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits practice page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thank you.